This is the jury charge for week 3 performance challenge. Ladies and gentlemen of the jury, at this point in the trial, I am required to inform you as to the law governing this case to guide you in your deliberations, period. This statement by the court as to the law of the case is known as a charge, period. It is also called instructions, period. It is my duty to preside over the trial and to determine what testimony and evidence is relevant under the law for your consideration, period. It is also my duty at the end of the trial to instruct you on the law applicable to the case, period, paragraph. You, as jurors, are to decide the facts in the case, but in determining what actually happened in this case or in reaching your decision as to the facts, it is your sworn duty to follow the law that I am now in the process of defining for you, period. You are not to single out any one instruction alone as stating the law, but must consider the instructions as a whole, period. You are not to be concerned with the wisdom of any rule of law stated by me, period, regardless of any opinion you may have as to what the law is or ought to be, it would be a violation of your sworn duty to base a verdict upon any view of the law other than that given in the instructions of the court, just as it would be a violation of your sworn duty as finders of the facts to base a verdict upon anything other than the evidence in the case, paragraph. Nothing said or done by the lawyers who have tried this case is to be considered by you as evidence of any fact, period. Opening statements of the lawyers are intended to give you an outline of what each side expects to prove so that you may better understand the testimony of the witnesses, period. The closing arguments are often very helpful in refreshing your recollection as to the testimony of the witnesses and such facts as may be developed, but it is my duty to caution you that your verdict shall not be based upon the statements made to you by the lawyers at the opening of the trial or upon their closing arguments, period. The function of the lawyers is to point out those things that are most significant or most helpful to their side of the case, period, and in doing so, to call your attention to certain facts or inferences that might otherwise escape your notice, period. In the end, it is your own recollection and interpretation of the evidence that controls in the case, period. What the lawyers say is not binding upon you, period. Your verdict shall be based upon the evidence as you heard it from the witness stand and as you remember it, comma, not as the lawyers or this court may remember it, period, paragraph. The evidence in this case consists of the testimony of witnesses who have appeared before you and testified, and the exhibits which have been introduced into evidence and which have been shown to you, period. You should entirely disregard questions and exhibits to which an objection was sustained, or answers and exhibits ordered stricken out of evidence, period. It is not the duty of the jury to determine the admissibility or validity of any exhibit or other testimony. Do not draw any conclusions or speculations as to why or why not certain testimony or other evidence was excluded or admitted, period. You are permitted to draw such reasonable inferences from the testimony as you feel are justified in the light of common experience experience, period. New sentence. In other words, comma, you may make deductions or reach conclusions which reason and common sense lead you to draw from the facts which have been established by the testimony and evidence in the case, period, paragraph. The law makes no distinction between the weight to be given to either direct or circumstantial evidence, period. It requires only that you weigh all of the evidence and be convinced of the defendant's guilt beyond a reasonable doubt before he or she can be convicted. You should carefully consider the testimony of each and every witness and not overlook any testimony or any evidence, period. This does not mean, however, that you must accept all the testimony as true or accurate, period. You are the sole judges of the credibility or believability of each witness and the weight to be given to his testimony, period, paragraph. As used in this charge, credibility of a witness means the truthfulness or lack of truthfulness of a witness, period. The weight of the evidence means the extent to which you are or are not convinced by the evidence, period. The number of witnesses testifying on one side or the other of any issue is not alone the test of credibility of the witnesses and the weight of the evidence, period. If proven by the evidence, you may believe one witness against a number of witnesses testifying differently, period. The tests are, how truthful is the witness and how convincing is his or her evidence in the light of all the evidence and the circumstances shown, ? In determining the credit and weight, you will give the testimony when a witness has testified before you, you may consider the following, his memory or lack of memory, his or her demeanor while testifying, his reasonableness or unreasonableness, his fairness or lack of fairness, and the intelligence or lack of intelligence of the witness, paragraph. A witness may be discredited or impeached by evidence by showing that he testified falsely concerning a certain matter, or by evidence that at some other time the witness has said or done something, or has failed to say or do something, which is inconsistent with the witness's testimony, If you believe that any witness has testified falsely, then it is your duty to give the testimony of that witness such credibility or weight, if any, as you may think it deserves, You may believe such parts of their testimony as you believe to be true, and reject such parts as you believe to be false.